Hi, I'm Art Bergeron, and the seminar you're about to see is the one I would have done at the Salt Marsh in January, but for COVID. This is about qualifying for MassHealth, and as I talk about during the seminar, it's about why you can always qualify, and I also talk to you about some of the ways in which you can always do that. I also mentioned, though, that if you are single, especially if you're single, and you also want to save your assets from any MassHealth liens, you need to do some planning ahead of time if you really want to save those assets. So if you got any questions, give me a call. My number is 508-860-1470. By agreement with my good friend Laura Stewart at the Salt Marsh, she also comes on in order to talk to you about the things that are going on at the Salt Marsh this month. So Laura, we've made it. It's January. This is the year, vaccines coming, spring's coming, this is all good.
Can't wait for June.
But in the meantime, we just got to stay safe. So what's going on at the Salt Marsh? How are you helping?
For having me, Arthur.
How are you helping people stay sane during these times?
Well, staying safe. We're not open to the public, but we are doing a lot of drive-throughs, which is great. So we get to see all of our members, and they get to drive through and pick up whatever we are offering. And in the past, we've offered soup and muffins and dinners. And now we've been offering, like holiday greens. People can come by. That was for Christmas. Yeah. So we're still working on programs for January for the drive-through. So check our website on the town website, or you can call us.
Call you at what? Yeah. Mm-hmm. No, you were just going to say it. Call what number?
Call 508-228-4490. We are also doing working with other websites. So if you get our newsletter, they are on there, and there's 4 of them that we're working with, and they're excellent. Keeps people very busy. And we've been having the hearing test. People are coming over. And we're also offering legal advice monthly. So we're keeping very busy.
Laura, that all sounds great.
Yeah.
Once again, the goal of the exercise is we just got to live through this. It seems always darkest before the dawn. I know it's bad right now, but it's getting close. Spring's coming, the vaccine's coming. Just stay safe. As I keep telling my clients, you don't want to be the one that next Christmas, they're like, oh, isn't it a shame that Auntie's dead, and can't be with us for Christmas,
Exactly.
You just want to be careful. We've almost made it now, so Be careful. So
Stay
Laura,
patient.
Laura, thanks a million for doing this.
Sure, thank you.
And enjoy this month, folks. I hope you enjoy the presentation. Once again, if you got any questions, give me a call. And if you want to stay connected and stay sane, talk to Laura. She's got a million things that are going at the Salt Marsh. Thanks very much. Thank you, Laura.
Thank you.
I'm Art Bergeron, and welcome back to the series of seminars that I'm doing regarding elder law issues, talking about my friends Frank and Mary. If you've been to one of my presentations at the Senior Center or the library in the area, you know that Frank and Mary's goal in life is to live in their house until they die and be buried in the backyard. They're just trying to take care of each other. They've got 3 kids. They want to make sure that following their death, their kids inherit whatever they have left. These are the kids, Peter, Paul, and Mary Jr. I always joke that if you're old enough to get that joke, you're old enough to be my client. So the goal of all of these presentations is really to just help Frank and Mary figure out the best way to deal with the rest of their lives and the best way to structure their assets so that at the end of their lives, their children end up getting the assets and not someone else. I always tell people, one of my goals in estate planning is to figure out the strategy through which you get the assets to your whoever you want them to go to, and to make sure that you cut out other people. I've never had a person who told me that they really want to leave some money at their death, for example, to the IRS or to the Department of Revenue, because they've just done such a great job. So typically, folks want to structure things so as to make sure that assets don't leak away. So that's really, one of the point of this presentation, because, and by the way, this is Frank and Mary's asset picture. They own a home worth $400,000. Frank has an IRA worth $200,000. They have joint savings of $200,000 for a total assets of $800,000. Frank has a Social Security check coming in every month of $2,000. Mary's check is half of Frank's, or $1,000 a month. They're also earning some money from their savings account and from the IRA, but we're not factoring that in here for purposes of this presentation. The point of this presentation, though, is to talk about probably Frank and Mary's greatest fear while they're alive, which is what happens if one of them needs nursing home care. As you know, they've got substantial assets, and therefore they're probably going to be fine until they die, unless they need nursing home care. The major reason for that is Medicare. Medicare was designed in order to make sure that if Frank or Mary got sick, they wouldn't go bankrupt as a result of getting sick. I remember reading this incredible statistic about Medicare that in 1960, something like 33% of all elderly households were poor. As of last year, that number was 6 or 7%. And the major reason was Medicare. Because Medicare takes care of you if you're sick in a whole number of ways. It just doesn't take care of you if you need a long stay in a nursing home, if you have cancer, if you need chemo, if you need transplants, if any number of things Medicare will cover. But they don't cover the cost of getting you fed, or helping you eat, or helping you dress, or helping you go to the bathroom, or making sure that you don't drift out into the street if you have serious memory problems. That's the reason why most seniors dread Alzheimer's more than they do cancer now. It's really an amazing thing. So this is the big fear. So I want to talk about what Frank and Mary can do to deal with that. Well, while Frank and Mary are both alive, that's all fairly straightforward. They really don't have to worry very much, because if Mary needs to go to the nursing home, she can qualify for MassHealth, which is the Massachusetts name for the Medicaid program, as opposed to Medicare, right? Fairly quickly. The reason for that is, in order for her to qualify, and by the way, once she has qualified, then her income will go to, if she is in a nursing home, will go to the nursing home. But all of her other expenses will be paid for by the nursing home. That's the reason why she wants to try to qualify for MassHealth as soon as possible. So Mary can qualify for MassHealth while Frank is alive fairly quickly. While she can own the home and can have up to $2,000 in countable assets, Frank could also own the home. So she could just transfer her home to Frank. Frank can have up to $128,640 in other cash or cash equivalent assets, and Frank can have unlimited income. So the strategy that Frank and Mary would use in this case would be that they would shift all assets from Mary to Frank at the time that Mary went into the nursing home. Now, once again, every senior knows that if you give away assets and need to qualify for MassHealth, that gift is subject to a 5-year look-back period. What many seniors still don't know is that look-back period does not apply to transfers between spouses. So even though Frank and Mary owned all of their assets at the moment that Mary went into the nursing home, Mary could shift her assets to Frank, and the day after she shifted them to Frank, she would no longer own the home in the case of the home, and as long as she shifted everything else out, she could meet that $2,000 asset criterion. So Mary can qualify for MassHealth by shifting all assets to Frank. Then the question is, can Frank meet that standard? If Frank owns the home less than $128,640, then Mary can qualify for MassHealth immediately. And by the way, when I'm working with folks who are thinking about this, I always try to focus on eligibility versus the MassHealth application. Once Mary is eligible for MassHealth, because these assets have been shifted, MassHealth will pay the nursing home retroactive to the day of her eligibility, as long as she applies for MassHealth by the last day of the 3rd month following the day of eligibility. So the thing for Mary to focus on in this situation is getting all of the assets to Frank and then getting his assets low enough. So now I want to talk about that a little bit. So the basic strategy is for Mary to shift all assets to Frank. There's no look back. We would typically advise Frank in this case to keep, say, $100,000 of the $400,000 in assets that they have, other than the house, because you remember he can have the house because he can own the house and still Mary can qualify for MassHealth. We would advise him to keep, say, $100,000 and to use the remaining money to buy an annuity. And as long as he does that, the day after, and it's an annuity of a specific kind, and we're going to talk about that a little bit. But the main thing is that as long as he does that, the day after he buys the annuity, Mary qualifies for MassHealth. Now, once she has qualified for MassHealth, her income from pension or Social Security is going to need to go to the nursing home. In this case, as we talked about earlier, Mary's income is only $1,000 a month, so that $1,000 a month is going to need to go to the nursing home. MassHealth is going to pay all the rest. So the only question then is, what kind of annuity does Frank need to buy in order to do this? It has to be a very specific kind of annuity. And by the way, now I know I'm talking to folks who, many of you will tell me, I don't like annuities, I don't trust annuities, annuities have a terrible rate of return, there are all kinds of problems with them. In many cases I agree with you. As an asset, as a profit maximizing matter, as an investment matter, the annuity may not be a good thing for you, although that varies because there are literally 100 different kind of annuity products that are out there. They're sold by all kinds of companies. I understand your concern that these things are being, peddled to you all the time, and you're worried about them. And by the way, in terms of the annuity that I'm about to talk about, this is not an annuity that Frank needs to buy ahead of time. He can literally buy this, as I mentioned in the earlier slide, the day before Mary tries to qualify for MassHealth. So what is it about this annuity that makes it special? Well, first of all, it has to call for equal monthly payments. The payments have to be over an actuarial term that is shorter than Frank's actuarial life expectancy at the time, right? If Frank is 80 years old at the point that all of this is happening, his actuarial life expectancy for MassHealth purposes is going to be, around 10 years, a little less than 10 years. And by the way, if Frank is looking for this annuity, he really wants to be talking to his elder law attorney to make sure he gets this right. Because the annuity company, if he is selling the annuity, and he asks the annuity company, well, what's my actuarial life expectancy? They may give him a life expectancy according to their data that is longer than what MassHealth considers to be his actuarial life expectancy. And when he goes to buy this annuity though, unless the annuity term, that is the term over which these monthly payments are being made, is shorter than MassHealth's version of his life expectancy, it's not going to be a qualifying annuity. Mary's not going to end up being able to qualify for MassHealth. So the annuity payments have to be over Frank's actuarial life expectancy. He can't have the ability to cash it out early, because if he could, then as far as MassHealth is concerned, the assets that were paid to that in return for that annuity, or the assets that he could still surrender, would still be considered to be his. That amount would then knock him over that magic number, the $128,640, which would mean that Mary couldn't qualify for MassHealth. So he can't be able to qualify, he can't be able to pull out money early. Now, he can specify that Peter, Paul, and Mary are going to be the death beneficiaries. Now, I'll tell you, there is an interesting thing that's happening at MassHealth at this point. MassHealth at this point is taking the position that if Frank were to buy that annuity and Mary were to die, MassHealth should be in the position to be the first beneficiary to get paid before the kids get any of the money. I will tell you, their position is contrary to case law in a number of jurisdictions around this country. And sooner or later, this is going to get challenged. And it may be in your particular situation, depending on what your situation is, that you may want to be challenging this. What we often advise clients is that they can name Peter, Paul, and Mary as the initial beneficiaries. But if that happens and Mary then, if that happens at this point, MassHealth may challenge the annuity. We feel pretty confident though that MassHealth challenge is going to fail. Bottom line is that following Mary's death, following Frank's death, Peter, Paul, and Mary Jr. can be the beneficiaries of this annuity. What we are sure of is that in that annuity, Frank does have to say that if he later needs to qualify for MassHealth, not Mary, but him, if he later needs to qualify for MassHealth and qualifies for MassHealth, MassHealth is going to have a lien on these remaining payments following Frank's death for the purposes of paying MassHealth what they paid on Frank's behalf. But the main thing is that the day after Frank buys this annuity, with these equal monthly payments coming to him, Mary can qualify for MassHealth. So while Frank and Mary are alive, it's fairly easy for one of them to qualify for MassHealth while still protecting all of their assets. Oh, and by the way, I just want to go back to one other point on these annuities. If Frank is concerned about that, as Frank is concerned, as Frank certainly should be, that if he dies, these remaining payments may have to go to MassHealth, Frank's way around that is to simply buy a shorter annuity so he gets his money back fast. Because as I mentioned, the annuity that is purchased by Frank, while it has to be shorter than his actuarial life expectancy, it can be much shorter. It can, instead of it being 10 years, it could be 5 years, it could be 4 years, it could be 3 years. If he structures things that way, then he'll be getting all of his money back fairly quickly. And remember, once Frank has it back, then the money's no longer subject to the MassHealth lien, as long as Frank does the right kind of estate planning. Which leads to, what happens if Frank has died? What happens if Mary is in the nursing home and Frank then dies and he's got these assets? Or what happens if Frank is worried that he's going to die and Mary might need nursing home care in the future? In that situation, Frank has a very simple strategy. And by the way, this is the typical strategy that I recommend to married couples, especially if both of them are healthy, is that you would have each of them do a will that specifies that following their death, any assets that they owned would go into trust for the benefit of the surviving spouse. So in this case, where it is clearer who's going to the nursing home first, because Mary's already going to the nursing home, Frank's going to have a will that says that regarding any of his remaining assets, like the house, his cash, any of the payments he would have gotten back from MassHealth, all of that is going to go in trust upon his death through his will for the benefit of Mary. This is not a trust that gets created at the time that while Frank is alive. It only kicks in after Frank has died. All of the assets that he was going to leave to Mary, he'll have go to in trust for Mary's benefit. You can name Peter, Paul, or Mary Jr. as the trustees. You can name anybody you want as the trustees, right? But if things are structured that way, then any assets that are owned by me when I die will pass through my will into this trust for Mary's benefit and will immediately be safe, non-countable, and non-lienable. While the assets don't have to be rearranged right now, if I'm Frank, they do have to be rearranged before I die. So I'll also often tell clients if they're both healthy, so simply you can wait. You don't have to restructure assets now. But if one of you gets sick, make sure the assets get transferred to that spouse so that before that spouse dies, the other spouse can be protected. But suppose Frank and Mary hadn't done that. And now, then suppose, like most couples, they own their assets jointly. And so Frank died, and then Mary became the sole owner of the assets. Now, let me tell you what Mary thinks could happen if Mary went to the nursing home the next day. Remember, these are her assets. She's got her house. Now she has Frank's IRA, and she has that bank account, still $800,000. Now her income has gone up to $2,000 a month from Social Security. What Mary thinks happens if she goes to the nursing home is that she knows the nursing home cost is going to be high. It's going to be about $12,000 a month. She knows that her income is $2,000, or about $144,000 a year. She knows that her income is about $2,000 a year, or a month, or $24,000 per year. Therefore, she realizes, or she thinks, that if she goes to the nursing home, she's going to be spending down, depleting her assets, burning them away, at the rate of about $120,000 a year, so that after 5 years, her assets will have evaporated down to $600,000. And there's only going to be $200,000 left for her kids. Now let me tell you what would really happen. If Mary needs to qualify, if Mary is in a nursing home and she needs to qualify for MassHealth, and she says to the folks at MassHealth that she intends to return home, then her home will not be a countable asset. If she's got these extra funds, in this case $400,000, she can actually put them into two different places. She can buy an annuity with them, very much like the annuity that Frank bought. I'm going to talk to you about that in a second. Or she could put the money into a so-called D4C pooled trust. In either case, the day after she does those things, thereby reducing her assets to less than $2,000, she can qualify for MassHealth. Once she has qualified, MassHealth will require that she keep paying her $2,000 a month to the nursing home. MassHealth will pay all the rest. Now, MassHealth will have a lien on these other assets, the D4C asset, the D4C money, the annuity money, and the house following her death to get repaid. And so Mary would say to herself, well, in that case, what does it benefit me to do all of this other stuff? The answer is very simple. Remember, if Mary is on private pay at $12,000 a month or $144,000 a year, she's paying. That's what she's burning away her money. Remember, the nursing home was $14,000 a month, but her income was $2,000, so it was costing her $12,000 a month. Once she's on MassHealth, however, MassHealth has a different rate for her nursing home bed, and that rate is typically around $7,000 per month. So if she's on MassHealth, she pays her Social Security to the nursing home. MassHealth is going to be paying this remaining money, $7,000 a month, or about $84,000 per year. Mary's new burn rate is going to be $84,000 minus her $24,000, which was the amount that she's paying to the nursing home out of her Social Security, are only about $60,000 per month. Mary's loss, therefore, at the end of the 5 years is not going to be what it was, which was $600,000. It's only going to be $300,000. Mary, at the end of those 5 years, will have $500,000 left to give to the kids, which is really what her goal was. Frank and Mary's goal was always to maximize the amount that was being given to the kids. So Mary not only can qualify for MassHealth, there's a tremendous financial benefit to her children to her to qualify for MassHealth. And I really want to emphasize that. As far as Mary is concerned in this case, if she needs nursing home care, she's not going to be affected one way or the other by any of this planning. She's going to be in a good nursing home. All nursing homes take MassHealth. Whether she's on private pay or on MassHealth, she's going to be in that same nursing home bed in the nursing home. The question is, does Mary want to restructure her assets so that most of her assets after she dies go to her kids, as opposed to having gone to the nursing home while she was alive? That's really the trade-off that we're talking about when I'm talking about these strategies. So there are two things that Mary can do. One, she can put her money into a so-called D4C pooled trust. What in the world is a D4C pooled trust? So if you want to learn about these, you should really just Google the term pooled trust, or Google any one of the existing pooled trusts. If you Google the term pooled trust, most of these names will appear. I'll tell you that we use Plan of Massachusetts and Rhode Island a lot. That's the one that's right on the bottom. When we're dealing with these things, because Plan of Massachusetts is located close by. It's located right on Route 128. But the concept behind all of these pooled trusts is the same. Basically, you take assets that you own, you transfer them to the managers of this pooled trust. All pooled trusts are managed by nonprofit organizations who work for the benefit of elderly and disabled people. You transfer all the assets to the pooled trust. The folks at the pooled trust then invest this money for you on your behalf. They're like money managers. They'll charge 1% per year for that investment, which is actually approximately the same that a money manager would charge you for giving you advice regarding the management of your money and actually managing it for you. The money, while you're alive, can be used in any way that would benefit you. Following your death, whatever money is left, entity that is the pool trust has the right to a percentage of that money to keep it. That percentage tends to run between 10 and 20%, depending on how long the money has been in there. But remember, their lien is only on the remaining money, so that if all the money has been used for Mary's benefit while she was alive, so that there's nothing left, well then the pool trust entity gets nothing. Finally, after the pool trust has paid itself, MassHealth has a lien on the remaining money, so that to the extent that a lien has accrued during Mary's lifetime, MassHealth would have a lien on that money in order to get it back. So typically the cost of these things are about $750 to $2,000 in an application fee. As I mentioned to you, they typically charge about 1% as a management fee. And then at the end, there's really a big range. They'll charge between 5 and 25% of the remaining money, typically depending on how long they've been holding the money. The use of the funds. These funds in the D4C can be used in any way that could benefit Mary. If, for example, Mary needs physical therapy, MassHealth typically does not pay for physical therapy services. They'll pay for the general services in the nursing home of feeding Mary and making sure that she can use the bathrooms and showering and things, but not physical therapy. It has been my experience that many seniors can really benefit from just that kind of physical therapy. And the D4C can pay for that. Suppose you're going to visit Mary once a day, once a week. Suppose she's not crazy about the food here, a very common situation in a nursing home. And so you want to have food catered in. You can do that. It could all be paid for through this. Suppose she needs better equipment. Suppose she needs a better wheelchair, better furniture in her room. Or remember, she still owns her house in the scenario we're giving you. So suppose there are bills for the house, like insurance or taxes. Remember, all of her income after Mary has qualified for MassHealth has to go to the nursing home. The D4C can be used to pay all of those expenses. So the bottom line is that D4C can be a handy device. What about annuities? We already talked about annuities a little bit. The annuity in this case would need to be irrevocable and unamendable so that Mary couldn't get the money back in a lump sum, because if she could, it would still be an asset of hers. It has to call for equal monthly payments, which have to start no more than 60 days after she's bought the annuity. The term has to be for a period of shorter than her actuarial life expectancy. If Mary were 80 years old, for example, her life expectancy would be 10.1 years, and MassHealth would have a lien on the remaining money. The interest rate on these annuities, by the way, is terrible. Right now it's about 1%. You would never buy one of these annuities if you were doing it as an investment matter. As a matter of fact, if you call an insurance company and say you're interested in one of these annuities and you start describing it, they'll say to you, oh, you mean a Medicaid qualifying annuity? The only reason why you buy these annuities is to qualify for Medicaid. The point is, once you've met those criteria, the money that has been paid to the annuity is no longer counted as one of Mary's assets. Now, once the annuity has been paid for, the payments that are coming in are part of Mary's income. So they're going to get added to Mary's income, the amount that's being paid to the nursing home. So now, given those two tools, let's talk about strategies. Well, one strategy would be, Mary could purchase an annuity. Remember, she's got $300,000. Suppose she purchased an annuity for 5 years. That annuity will pay her back approximately, assuming very little interest, $5,000 per year during those 5 years. And suppose she takes the remaining $100,000, remember she had a total of $400,000, and uses it to buy and puts it into the D4C. She then keeps the house, and the D4C money is used to maintain the house. If Mary dies after 5 years, there is no MassHealth lien, because remember, the amount that MassHealth is charging as a lien is the difference between what Mary is paying from her income to the nursing home and what the nursing home rate is at the MassHealth rate. In this case, the MassHealth rate is $7,000 per month. If Mary's got an annuity that is paying $5,000 a month and her income pays $2,000 a month, she's actually paying all $7,000 a month every month. At the end of those 5 years, that means MassHealth has no lien because MassHealth hasn't had to pay anything during those 5 years. So Mary's house basically ends up being totally safe. And there are some remaining funds in the D4C, and they're going to be safe too. So the bottom line here is that Mary has these two, I want to say they're easy strategies, but they are both strategies that she can execute in order to deal with qualifying for MassHealth. She can keep her house. All she has to do is say that she intends to return home and she's going to be able to keep it. She can put money into the D4C, and that money can be used to pay for that house. And then she can purchase an annuity. And as long as the annuity payments plus her income end up equaling less than the cost of the nursing home bed at the MassHealth rate, she effectively ends up saving a huge chunk of her money. So the goal of the exercise here, of course, is to sleep well at night and to make sure that that things are structured so that you can feel like you're safe. But if you run into this situation, and many people do, where one spouse needs nursing home care and the other spouse is like, oh my God, what am I going to do? Or one spouse is dead and the other one needs nursing home care, and the kids are saying the same thing, oh my God, what am I going to do? The answer to that question is, don't assume that you need to be just paying the money, all of the money to the nursing home. Go talk to somebody and figure out a strategy. It's going to help you and it's going to help your kids. Thank you very much.